Good morning, Your Honor. William Sykes, along with Michael Guyan, Brittany Watkins, Richard High from Klagen Sykes Law Firm on behalf of the state. We also have Mark Kruger and Raquel Fulgram here on behalf of the state. We have David Slade here. We also have Brian McMath, Brian Moore from the Nashawati Law Group observing. And I might be missing a couple of folks, Your Honor, but I think that covers most of the people who at least are here in the room.
We did get all the check-ins with the clerk, so I do appreciate you going back through the names. And of course, with regard to the caption, we can see the various firms that are represented and who is going to be present. I take it, Mr. Sykes, as since you conducted the introductions and began, that you would be making argument here today on the motion of reconsideration.
That's correct, Your Honor.
All right, let me come over to the side for Snapping.
Good morning, Your Honor. Alex Fugazi and Jonathan Blavin on behalf of Snapping.
Good to
And I
see
believe
you.
we have a couple of colleagues from our SCAD NARPS, our Pro-Hoc Council, and I can't see all the names right in front of me, but I believe there are a few observing only, Your Honor.
And that's fine. Of course, we're more than happy to have anybody observing. And I note that we have obviously some videotaping going on. I didn't recall if we had prior, if this is media, if we have prior approvals or something, but nobody seems to be in concern. And I have no concern that we would have whatever's occurring here today to be reviewed that way. So let's jump right in. Plaintiff, State of Nevada, has filed a motion for reconsideration. It is asking the court to reconsider based on its prior order that did in fact dismiss a number of claims that had been brought by the state, not all the claims, but some of the claims, and what is in dispute in terms of whether the court, as the plaintiff has argued, either misapplied the law or misapprehended some facts, or perhaps there were some new facts disclosed. But ultimately, whether the design defect and failure to warn counts 3 and 4 and the unjust enrichment counts 6 were improperly dismissed at the time based on the court's findings, and what the plaintiff has argued was perhaps some undue reliance on how the defendant identified their services / product, etc., and some references again to additional statements made more recently since the court's decision about identifying themselves as a product-based company. So there's a lot of moving parts here in terms of what is being brought forward for the court's consideration. But the reality is the court does have the inherent authority to reconsider its prior decisions at any given time. We do not have anything that is the law of the case, so to speak, at this point that we would be bound to. And we obviously, as a court, always want to make the best effort to get the decision right, so to speak, or at least our best take on what the law would dictate to us would be the circumstances. And to the extent that there is something that might show us that we either misapprehended a fact or misapplied the law in some way, is welcome for reconsideration. So I'm not concerned with the ask. I obviously just want to get to the heart of the substantive argument. So, Mr. Sykes.
Thank you, Honor. And I'll kind of cut to the chase. So the state's concern with the dismissal of the product liability claims, and I'll start there, there is a pretty sizable split of authority currently in the country about whether or not social media applications and mobile applications in general are products, or at least can be products.
And the Snap side argues that it really isn't a split and a sizable agreement on, in the sense of like 50-50, that there may be some cases where those things have been decided, and you cited some out-of-state cases for that purpose, but they focus on and point to what appears to be much more of a vast majority of saying that this is not the situation. So I want to just clarify, when you say split, I think people hear and consider, oh, well, this is really kind of 50-50 and at some point needs to be decided. Nevada hasn't decided it in your favor, certainly. And we see a lot of references to federal case law and other things. But at the end of the day, is this truly a split situation, or is this the vast majority is still maybe catching up with the times, as you have argued, but still stands for the situation that this is a service and not a product?
Well, Your Honor, as has been pointed out by courts around the country, this is a novel question of law. We couch it as a question of a mixed question of law and fact, because there is some factual analysis, because you're looking at a brand new type of product. Snap has only been around since 2011. Obviously, social media did not exist when the second restatement of torts was done back in 1965. And when I say a split of authority, if you look at the recent decisions since we last argued this motion, the trend is leaning in the state's direction, Your Honor. And I'll give an example. We have the NRA Uber Tex case, and I'll provide the site, Your Honor. It's a federal case, and in that case, they specifically state, and this is 745 F sub 3D a third of 869, and this is on pages 904 and 905. And in that case, the Northern District of California states the restatement takes no official position on whether software should be considered a product. And I'm quoting, the commentary, however, suggests that the reporters believe that it probably should be, at least where it was mass produced rather than custom made for a particular user. The reporter's notes state that, quote, numerous commentators have discussed the issue and urged that software should be treated as a product, unquote. And the case continues on. And it suggests that courts considering the issue should take guidance from decisions that have held that mass marketed software is a, quote, good under the Uniform Commercial Code. And it says that the Ninth Circuit once suggested in dicta, computer software that fails to yield the result for which it was designed might appropriately be recognized as a defective product. And this case came out, Your Honor, August 15th of 2020.
Right, you're focusing heavily here on software. You know, when I was reading the briefs and to prepare for today's argument, of course, you seem to focus more, I think, broadly than that, even on sort of the infrastructure of what it takes to operate I'm going to call it a platform right now, because you'll say product, they'll say service. Let's just talk about it in sort of like a non-legal way, I guess, to sort of identify it. But you're talking about software here. I'm really not sure that we have well, let me back up. Like I said, we're clear that Nevada hasn't definitively determined this issue yet. And I don't know where the other cases stand, and I don't know if any are in a writ process, or depending on the decision here, whether there would be a writ process to see if our appellate courts want to weigh in on this. But at the end of the day, when we're looking at other things, you know, as you said, perhaps maybe there is some trend to wanting to recognize this platform as being a product for purposes of allowing some of these causes of action to be sustained. But is it not still the overwhelming amount of case law out there that this is not a product, and or that this issue of whether it is a product is a question of law that can and should be decided in these ways versus being a factual question? And I know I kind of compounded that, but
Right. So to address your first question, Your Honor, the recent case law, the vast majority does not support SNAP's position. I would say at best it is a split. And when I say recent, I mean since we last argued this motion several months ago. And the issue that we're having is Snap and a lot of these other social media platforms are a brand new type of product. And so courts have been struggling with this issue for several months. The recent decisions, the recent trend is that, yes, a social media platform or an app that you download from an app store is a product. And the reason we cite the Uber case is Uber is an app that you can download on your iPhone, just like Snapchat. And in the Uber cases, what was alleged in those cases, and they allowed the product claims to move forward, at least past the motion to dismiss stage. What was going on in those cases is riders were being sexually assaulted. And the allegation was there weren't sufficient security measures in place to prevent that from happening when Uber was connecting these riders to the drivers. And Your Honor, we have some similar allegations here. I'm looking at paragraph 143 of our complaint against Snap, and I'm quoting, this is paragraph 143. In another instance, a 25-year-old used Snap Map, which is one of the design features of Snap. A 25-year-old used Snap Map to hunt down and sexually assault a 16-year-old in Florida. Okay, that's paragraph 143. Paragraph 150, we're talking about issues that are happening on social media, cyberbullying, sexting, self-harm, violence, sexual harassment. That's paragraph 150. Continues on. Paragraph 186. Snapchat provides fertile ground for bad actors who use the platform expressly to harm young users. The National Center on Sexual Exploitation has placed Snap on its Dirty Dozen list multiple years in a row, calling the platform dangerous by design, by product design. Again, very similar to the issues with the Uber app. And this is a quote from that website citing Snapchat as a top spot for sextortion, sexual interactions between minors and adults, and pornography exposure. And Your Honor, the cases that we cited all involve apps like Snapchat that you can download where the apps are being used to sexually assault others. And so in that sense, they're very analogous. And so that's why we cited the cases we cited. Snap has taken the position that it seems that a social media application or an app that you download cannot by law be a product. That's simply not the case. Your Honor, at a bare minimum, Snapchat, like all of these other apps where product defect claims were allowed to proceed, has designed elements that can and have caused harm. And that's where the state is coming from when we're bringing up these new authorities that have just recently come out within the past 6 to 7 months. With regard to, I want to address the issue of tangibility, Your Honor, because this is important, because I think Snap hung his hat on that. That Snapchat is not a tangible product. The recent trend of cases says that tangibility alone is not determinative. You look at whether or not it's analogous to a tangible product. For example, one of the issues we have with Snapchat is the lack of parental controls. What other courts who have recently addressed this with other software applications have said that parental controls are similar to a tangible product. For example, a lock on a baby gate, or if a child needs prescription medications, you have a particular type of bottle that is child-proof. So in that way, it's analogous to a.
But you're pointing to, if I'm understanding, I want to make sure I'm following. They don't have parental controls, but because parental controls are a product, it should be considered a product. I'm not sure I followed the.
I apologize for, let me be more specific, Your Honor. We believe they have insufficient parental controls or defective parental controls. And to the point where it makes it so the parents have very little ability to supervise or control what their children are doing on these applications. And these are applications where children are interacting with complete strangers. And Your Honor, if you had any type of product in the real world where you had children interacting with complete strangers, including adults, there would be some requirement for supervision, some requirement for adult supervision and parental controls. It's our position that Snap doesn't offer sufficient parental control and supervision, and that's part of our defect claim. They're moving on to another example, and this is an application, Judge, mobile app where you can download on your phone. There's Doe versus Lyft. Unfortunately, similar issues there where an individual was sexually assaulted when a driver pretended to be a certified licensed driver through the app, but really was not, was really a convicted felon. They dropped this woman off, followed her into her home, and then she was raped. In that case, the court determined that yes, Lyft is a product. The design features, the lack of security features caused or contributed to that harm. And the plaintiff proceeded sufficient allegations to get past the motion to dismiss stage. And so that's kind of the issue we have here, Judge. We've pointed out several elements of the Snap platform that are defective as a product. This is consistent with the cases that we cited involving other applications where the product was cited as defective as designed. We're not talking about third-party content. We're talking about the design of the product itself. And that's why under the BuzzFeed standard, the question is there any set of facts that we can allege or prove to get past the motion to dismiss stage? Your Honor, the answer is yes, at least with regard to the product liability claim. And so another case that's important to note, Your Honor, is the Schuler case. And that is a Nevada case. And that undermines, Your Honor, their position that it must be mass produced. Schuler involved a sign at the MGM Grand, custom made, it was unique. It was a one-off. And Schuler said it doesn't have to be mass produced in order to qualify as a product. Schuler, Your Honor, I think does a good job of going through the history of product liability, why product liability exists. And I think that's something that may have been given short shrift by SNAP in the prior pleadings. The policy considerations, Your Honor, favor us here. And if you look at Schuler, it says a case-by-case approach is preferred because it allows the doctrine to adapt to technological advances, which is particularly beneficial in the current climate where advances in technology occur frequently. That's a concern we have, Judge. This is a new product. It's a new thing. And even if the court's inclination is, well, it's at least a combination of a service and a product. If that's your inclination, Your Honor, at least we should be allowed to conduct some discovery on that issue and get past the pleading stage. So we can flesh those issues out. Not only that, but I would bet that if this case does continue on the product liability claim, there will be additional guidance from other jurisdictions and possibly even the Nevada Supreme Court on this issue.
Can I ask, I think I asked this before, so forgive if I did, but maybe there had been further developments. I know that there's another case with multiple parties with similar arguments occurring in one of the other courts in this jurisdiction. And I'm just curious, do we have divergent opinions on this, or do we have the same opinions on this situation? Because I have, like I did before, not looked to see what the other judge in the other case is doing. But I'm just curious in terms of how it might be lining up in terms of further review.
Your Honor, I can certainly speak to the case against TikTok in front of Judge Kishner. I believe that case is under advisement. I can tell you the concern that at least she intimated from the bench, and I'm not saying this is a ruling, Your Honor, so I don't want to put this as a ruling. But the concern that was intimated from the bench was the quote I just provided, that the second restatement of torts is designed to adapt and evolve to technological advances.
Okay.
And that seemed to be a sticking point for her.
But there's no contrary opinion at this point, even among the colleagues.
Let me double check, Your Honor, but not that I'm aware of. All right, so Your Honor, it's my understanding that with regard to Meta, I believe the product defect claim did survive, but there is a second, there was an amended complaint. We were allowed to amend to add additional facts, additional allegations in support of the product defect claim. And there's a second round of motions to dismiss pending.
Okay.
And that's another thing, Your Honor, at a minimum, we would request that we at least, and that was one of the concerns we had with the order, it didn't give us the opportunity to amend.
Well, it did indicate it was without prejudice, though.
It did, and so it was that maybe part of our motion is kind of a motion to clarify is it's without prejudice. However, the conclusion did say that it was we were not given the ability to amend, and so we certainly would request at a minimum the ability to amend if the court thinks our allegations are insufficient. We think they are, but we do believe there is a set of facts that we could allege and prove that would survive the +2 standard on a product liability case.
Well, I think to clarify, if need be, for that piece, when there's not a motion to amend and we haven't been asked to consider it that way, which I don't recall being a component of the prior discussion and analysis, then it's without prejudice is by definition, if you believe as the case proceeds that you come up with factual basis to seek to amend, and there are deadlines within a case for amendment, that can potentially be undertaken. We don't typically send something out when a dismissal is granted and say, okay, go amend, unless that request has been specifically made and granted, which is what I think is the difference here.
Okay, and Your Honor, I guess my concern was the way the order was worded. We weren't sure whether or not we would still be allowed to do discovery on the product liability claims. It did say without prejudice in the body of the order, but then at the end it said the request to amend.
Well, the discovery disputes would have to be raised through the pendency of the case, and obviously you're allowed to discover relevant evidence or evidence that may lead to relevant evidence, and to the extent that again, it was without prejudice. I can't sit here and say there was anything in the order or anything intended by the order to preclude you from being able to discover the case that you have, and to the extent as you go along, discover things that may warrant asking to amend, and then including additional discovery. That's why the amendment deadline, in the court's opinion, is well in advance of when the discovery cutoff deadline is so that if something comes up and you seek to amend and you're successful in doing so, you have ample time to continue to discover it. But no, this would not be a case that would go forward out of the gate unless the court reconsiders today as a product liability discovery. No, that would not be appropriate.
And that's our concern, Your Honor. We think the cleanest way to handle this is for reconsideration of the decision, allow the claim to proceed for now. And then if, as the case develops, obviously there'll be motions for summary judgment down the road, and then we can flesh out those issues. But we've listed out several design elements that are defective as a product. And in terms of the representation Snap has made, and another point, Your Honor, Schuler was actually decided on a motion for summary judgment. And that case got past summary judgment. Now that did involve a marquee sign, which is technically a tangible product. But again, the recent case law says tangibility is not the standard. It's whether or not it's analogous to a tangible product. It doesn't have to be a physical tangible product.
Schuler was also cited for the proposition that this can be decided as a question of law.
It can be.
Is not a mixed fact law question. So therefore, if we look at Schuler for all the propositions, including that, then it still would be fair game to make that decision today, or have made that decision previously and not reconsider it today. But I think your point being that we should look at it from the standard of if there's any set of facts that can be proven, and you believe that there's enough case law out there that indicates that this could be treated as a product, that the court should give sort of the benefit of the doubt, even though there's no such Nevada case law. And there seems to be some contrary, I would say, law to that effect available, that we should focus on the trend and give the benefit of the doubt that this could be deemed a product, so therefore put these claims back in. Is that a fair, not trying to in any way undermine your argument, but just trying to summarize it, if that's a fair summary?
That's part of our argument, yes, Your Honor.
Okay.
That you stated that part of our argument correctly. And additionally, I think the issue we have, Judge, is there are a number of different things on this product. For example, the Snap Map. We cited in our complaint a specific example where a child was raped as a result of that design element. It had nothing to do with third-party content. It had to do with the design elements of the application. And in terms of looking at whether or not Snap holds itself out as a product or service, they hold themselves out as a product, Your Honor. And I know they cite case law for the proposition that, well, you can't use out-of-court statements against us in court. Frankly, Judge, that flies in the face of the exception to the hearsay rule, admission of a party opponent. Otherwise, that rule wouldn't exist if you can't use out-of-court statements against someone in court. And to that point, I want to talk about the 10K statement they filed with the SEC, which they filed, Your Honor, after they won the motion to dismiss product liability, claiming that their product was a service. So yes, this is new information. They could have changed their 10K statement. They could have changed their documentation to reflect that they're a service and not a product. They chose not to. And here's what they're telling the SEC and their investors. We have it here on the screen. And this is a quote from the annual report that they filed on February 5th, 2025, less than 2 months ago. Our flagship product, Snapchat, is a visual messaging application that enhances your relationship with friends, family, and the world. They use the word products over 333 times. And this is a document filed with the SEC. And this isn't an informal document. It's not puffery. This is their statement to their investors. And they use the word or the phrase, our products, 128 times. And we'll see who this was verified by, if we can go to the next slide. So even Spiegel, who is the CEO of Snapchat, certifies at the end of the 10K statement, quote, I have reviewed this annual report on Form 10K of Snap Inc. Based on my knowledge, this report does not contain any untrue statement of a material fact or omit to state a material fact necessary to make the statements made in light of the circumstances under which the statements were made. All right. And they're not misleading with respect to the period covered by this report. Somewhat similar to the agreement you have to make when you're making representations to the court. Okay, so they're telling the SEC one thing, Your Honor, and they're telling you something different.
Is it possible, Mr. Sykes, that there could be the term product utilized in a way that is meaningful in a 10K filing or and a product as it's used in a product liability case, and that the case law could distinguish those things and that there could be some differentiation in that?
That's possible, Your Honor, but as of right now, that sounds like a factual issue to me. And if there is a factual, if they dispute their own 10K filing, and if they dispute what they mean by a product, I think that's something that's right for discovery. Not only that, Your Honor, if you look at the very structure of Snapchat, we have this in our reply brief. They have job openings for product design engineers. They have job openings for, and we'll provide a list here. And I have a longer list in my notes. And that will pull up shortly. And so here's a list of job openings currently for Snapchat. And Your Honor, this is on Google. If you Google Snap product developer, it yielded over 22 job openings for the following: product design engineer, core product designer, lead product researcher, product manager, signals and measurement, product manager, Snapchat, associate general counsel, product AI, product counsel, Snap Lab, staff product manager, product marketing manager, product owner, Lens Studio. Lens is one of the things that we're suing over, Your Honor, their Lens feature. Staff product manager, product owner, product AI specialist, mechanical product engineer, systems and product engineer, software engineering for consumer products. These are job titles that are all open right now. Technical product designer, product visual designer, product design engineer, camera innovations, senior interface designer for Snapchat products, technical lead, AI-driven and ad product development. Judge, they are a product. They call themselves a product to everyone except for import. And they have not presented, from what I can tell, any examples where they refer to themselves as a service outside of this court. And at a minimum, Your Honor, we're entitled to know why they call themselves a product, right? If that's what they're representing to the public, if that's what they're representing to United States regulatory bodies, we're at least entitled to do discovery on that, if nothing else. However, Your Honor, I think the trend in the case law supports our position. Snapchat is a product, or certainly can be considered a product. At a minimum, some of the design elements are products. And a lot of the courts have split that hair and said, well, we're not going to say that the entire application is a product, but there are certain aspects of it that are, because they're designed by Snapchat. They're distributed by Snapchat. You go to an app store to download it, and there is consideration paid. And so, Your Honor, with regard to the product issue, I'm happy to answer any other questions you have. I'm also happy to go through the other case law that we cited. We brought copies for you, Your Honor. I know the court typically doesn't use Lexis sites, so we did bring copies of those decisions for your review or for your clerk if you want those.
We saw the briefing and we revisited some things, and obviously we had addressed, for instance, the Lemon case and some of the other cases that you've listed here. So I don't know that we need those copies at this time, but if we do decide to take this under further review, we would potentially ask you for them.
Okay, thank you, Your Honor.
Do you want to touch upon the unjust enrichment?
Yes, Your Honor. Would love to go through the unjust.
I mean, we obviously have it in the briefing, so if you want to submit on that, you're fine to do so. But if you want to highlight some things, that's fine.
Yeah, with regard to unjust enrichment, I think the key things is the expectation or receiving a benefit. Snapchat is essentially arguing that they receive no benefit because no money is exchanged. And Your Honor, I think we roundly fleshed that out in our briefing. Money is not required to be exchanged. It could be any advantage. Courts around the country have found that, and there are cases on both sides, Judge, but there have been several court cases that have found that an advantage can be the transfer of personal data. We know it's an advantage for Snap because that's how they make their money. They made in excess of $5 billion this year. Over 3 billion of that was in North America by using targeted ads and advertising using people's personal data. So if that's not a benefit, Judge, I don't know what is, if you're making that kind of money off of people's personal data.
But the analysis, counsel, isn't that they benefited, isn't the analysis that the state is the party here. I understand you're standing, as the state for its citizens and whatnot, but that the action of conferring the benefit, what you're basically saying is people use the product, and if they use the product to monetize with the people, that somehow that's the people conferring the benefit for unjust enrichment purposes. It's really hard to make that connection. And if you can do it a little bit better or point to some case law, which I've not seen, I'd invite you to do it.
Your Honor, we've submitted all the case law in our briefing. What I can tell you is that when the state brings these causes of action, standing in the shoes of the consumers, we absolutely are allowed to ask for unjust enrichment on behalf of the consumers of the state of Nevada, particularly the children. And that's what this case is about. It's about young users under the age of 18. They are conferring a benefit to Snapchat. And standing in the shoes of the consumers, we are allowed to seek compensation.
But what I'm trying to understand is, can you just connect the dots maybe a little bit better? They're users. Simply by being users of a platform, they confer a benefit. Is that the argument? I'm just trying to make sure I understand the argument.
No, and I apologize, Your Honor. It's not that they're just users of the platform. It's that while they use the platform, Snapchat is tracking their location, tracking their likes, tracking the information they interact with the most, and they're selling that information of children. They're selling children's information, children's habits, children's potential ages.
I see that argument in terms of monetizing and maybe going toward the product argument that you've made earlier. I'm struggling to see that argument as that is the user conferring the benefit. They're taking perhaps monetary advantage, if you want to call it that, of the users for their own benefit. But how is the user? It really sounds like you're arguing that simply by being a user, that they are then conferring a benefit actively on Snap.
But it's not just by being a user. It's by agreeing to provide their personal information and data to Snap, which Snap then monetizes. And Snap is being unjustly enriched because it's making billions of dollars while these applications are being used due to defective design, are being used to provide access to children through sexual predators, sexual exploitation, child molestation, rape, sexual assault. And Snap should not be unjustly enriched by keeping the benefit of the money it's making off of these ads, when ultimately this software is resulting in children being harmed every day.
Okay. Anything else?
If you have any questions, Your Honor, I'd be happy.
No, I've kind of done them throughout the
right.
argument. So
I would like to reserve an opportunity to respond to Snap's arguments.
that's fine. You do carry the burden here on your motion reconsideration. Mr. Blavin, are you going to be the only one arguing today?
Yes, I will. Thank you.
And can I just jump in? I know you're going to cover whatever it is that you need to cover, but it is a little disconcerting after we have our hearing and we make our ruling that the public filing gets issued and you all go out of your way to talk about and aggrandize your product. And it would be helpful to kind of see how you're going to distinguish it. I saw the argument that just because we make public statements someplace else doesn't mean that should carry the day. Okay, at the end of the day, yeah, the court does have to make a decision on what binding law and persuasive law through the case law interpretations of the statutes and arguments are. But when you go out of your way to tout your product, how does the court, how do you come in today and have the court understand that your statements publicly after this court made its decision shouldn't be counted and shouldn't weigh in favor of reconsideration, at least at this stage?
I'll start with that issue, Your Honor. And I think what is true is that Snapchat, other platforms like TikTok, Instagram, etc., have colloquially referred to their platforms in certain respects as products. And that's been happening for years. I think these issues were raised in the original motion to dismiss briefing, and the court rejected them then for the very reason that Your Honor articulated right now, which is using the word product in a non-legal sense is not dispositive, and courts repeatedly have rejected this argument. So for example, in the coordinated California state court proceedings, which involve thousands of cases from around the country, and including, I believe, cases from Nevada, the court dismissed the product liability claims against Snapchat and the other platforms. And as to this particular argument, the court said that the fact that defendants have referred to their platforms outside of the litigations as products was not persuasive. And the court specifically noted that whether based on the terminology used by the creator of the instrumentality is irrelevant to the legal analysis, the question of law, as to whether or not these platforms fit within the definition of product. Multiple other courts have held the same. In the Jacobs case versus Airbnb from the Central District of California that we cited, this argument was made again. Snap refers to itself as a product. The court said the use of the term product does not resolve the question of whether, in this case, the platform represents a product for purposes of product liability analysis. The court in the Burkhart versus South Correctional Entity case from the Western District of Washington held the same. So Snapchat, other platforms have, in a non-legal sense, said, hey, we have product designers on the team. We have products. I'm sure if you go back to Mr. Spiegel's statements prior to the one made just recently, it probably referred to Snapchat as a product. But for purposes of the legal analysis as to whether product liability law should apply to these platforms, it's irrelevant for the reasons Your Honor identified, and multiple courts have held the same.
Do you concur that the evolving case law is trending away from Snap's position and towards, for instance, in this case, the state's position, but evolving away from Snap's position and finding that the products liability case can at least, or claims can at least survive motion to dismiss?
I don't, Your Honor. I think the weight of authority consistent with your court's ruling is that Snapchat and other social media platforms are not products within the meaning of product liability law. As your Honor asked, what the courts in the other cases have held, in the TikTok and Meta cases, at least on the original motion to dismiss, the courts reached the same conclusion that Your Honor reached. We attached the order to our briefing from those cases. I'm happy to hand it to Your Honor if you would
It's
like.
okay, make your representations as Mr. Sykes did, and we'll
Okay.
see if we need to take anything with us.
It's exhibits 1 and 2 to the appendix filed. These were the cases involving Meta and TikTok. The court applied Nevada product liability law, and the court determined under Nevada product liability law as to TikTok, as to Meta, again, very, very near identical allegations that there's insufficient parental controls, that there's harmful users on the platforms. The courts there reached the same conclusion that Nevada product liability law does not recognize these online platforms as products, notwithstanding how they may describe themselves. So for example, with respect to TikTok, and this is exhibit 2 at page 12 of the order, the court said the second restatement states that products are tangible items such as tires, automobiles, and insecticides. And there, Judge Kishner said TikTok does not fall within the meaning of Nevada products liability law. The court, in fact, cited in that order the very case that the state relies upon here, the Schuler versus Adart case, and said under that precedent, it wouldn't fall within the scope of product liability law. And that's because in the Schuler versus Adart case, the court specifically noted at page 452 to 453 that the restatement provides a, quote, non-exhaustive list of tangible items to which the doctrine applies, referencing an automobile, a tire, and an airplane, which the court said, quote, should serve as guideposts to ensure adherence to the doctrine's stated purpose. And the court cited that as well in the case against Meta, and holding that Meta was not a product liability law. So as of right now, the Nevada courts are unanimous that none of these online platforms constitute products within the meaning of product liability law. And that determination is consistent with several other cases. We cited the Zinchik versus Snap case from the Central District of California, holding that Snapchat is more akin to a service than a product. Again, California state court proceedings where you have thousands of cases around the country, multiple jurisdictions, laws. The court there dismissed the product liability claim against Snapchat and other platforms, holding that they are services that, quote, facilitate an interactive experience. The In Re Facebook case from the Texas Supreme Court in 2021 held the same as to Facebook. The Jackson versus Airbnb case held that Snapchat is a platform that connects users. It's more akin to a service than a product. The Jacobs case I referenced before held the same as to Facebook. all of these cases, Your Honor, and I count 7 of them specific to Snapchat or other social media platforms, have held as a matter of law on the pleadings without the need of any further discovery that these platforms do not constitute products within the meaning of products liability law. And the state's allegations in this case make that clear. For example, paragraph 30 of the complaint says that the core product on Snapchat is, quote, an image or video that is sent from a user to one or more people on the platform. Clearly, that's a communications service. In its very own reconsideration motion in this case at page 11, the court characterizes Snapchat as a, quote, system that enables real-time interactive digital communications. Again, that is a service that facilitates communications between users. And I think the weight of authority is on our side. The authorities that the state primarily relies upon, the newer authorities involving Uber and Lyft, again, those are not social media platforms. They don't really facilitate communications and connections between users. They also involve issues of physical products, cars that are tied to those apps. And Your Honor, at best, even if you took those authorities into account, the only thing they demonstrate is that whether product liability law applies to an online app such as Snapchat is unsettled at this point. But that doesn't come close, Your Honor, to satisfying the motion for reconsideration standard. And as the Nevada Supreme Court has held, it is a very high bar. You need to show that the ruling was clearly erroneous or that there's some new material fact or information which would warrant a new decision to come out, in contrast to the prior decision. And the Nevada Supreme Court made clear in Moore versus City of Las Vegas that only in very rare instances should the court reconsider its prior decision, because then you're always going to be rehashing issues that have previously been litigated. And that really, for the most part, Your Honor, is what the state is doing in their motion. They're trying to rehash an issue which was extensively briefed, argued, and litigated and resolved. Your Honor's decision on the product liability claim is consistent with the Nevada court's decisions as to TikTok and Meta. It's consistent with a broad swath of other case law holding that online platforms such as Snapchat are not products. And it is clearly not clearly erroneous. And it was correct as a matter of law, Your Honor.
Okay, do you want to touch upon the unjust enrichment or just submit on that?
I can briefly touch on the unjust enrichment claim. I would note that as with your Honor's ruling on the products liability claim, the courts in the Meta and TikTok cases reached the same conclusion in dismissing the unjust enrichment claim too. And they did this for the reason that Your Honor identified, that there was no benefit that was conferred by the state on those platforms. And the court said in those cases that because there was no benefit conferred by the state simply has not pled an adequate unjust enrichment claim and dismissed on that basis. The state, again, today does not identify any new authority supporting their proposition, nor do they suggest that there was any ever type of benefit conferred by Snap on the platform itself. And Your Honor also dismissed on 3 other independent grounds the unjust enrichment claim, which is not addressed by the state, including that the state, at the hearing at least, that Your Honor noted that there was no benefit conferred, even if you take into account their theory that users conferred a benefit. And that's because there is no benefit from intangible items like user data and engagement. That's courts have said, multiple courts have said, that's just not a benefit within the meaning of unjust enrichment law. And the state still does not cite a single Nevada case where the court has held that user data or engagement constitutes a benefit for purposes of unjust enrichment law. And again, even if Snap received a benefit, unjust enrichment is an inappropriate remedy here. The state has other claims which are moving forward, including their negligence claim. The user relationship with Snap is governed by a contract, and therefore it's just an inadequate remedy to have unjust enrichment claims. And then as a matter of policy, to the extent the state is advancing policy arguments, those are more appropriate to the legislature or to the Nevada Supreme Court. And again, they have other claims moving forward in which they can pursue their remedy. So there's no need to revive their unjust enrichment claim.
All right, thank you, Mr.
Thank you, Your Honor.
Mr. Sykes, some brief rebuttal?
Yeah, thank you, Your Honor, and I'll be brief. The representation as to what happened in the TikTok case, Your Honor, is not correct. The judge initially granted her motion to dismiss with the caveat that she allowed us leave to amend, which we did. And the second round of motions to dismiss are pending on that. And again, from the bench, Judge Kishner's concern with dismissing those claims now is that the second restatement of torts is to allow for technological advancements, and it has to be done on a case-by-case basis. If we're relying on what the second restatement of torts provided as guideposts in 1965, we're going to be woefully behind the times when we're talking about new technological advancements. So addressing that point. Another issue I want to bring up, and they talk about cases with thousands and thousands of plaintiffs or users in the California state courts. And I'll list them here, Your Honor. I believe there's Jacobs and a few others. And I'll tell you what the Northern District of California said. And so he cited Jackson versus Airbnb, Jacobs v. Meta Platforms, and Zinasek versus Snapchat. Here's what the Northern District of California said about the rationale in those cases. And this is a more recent decision. We cited this in our reply. And it says, these cases offer minimal, if any, rationale for their classifications of social media platforms and services. So those courts, they made the rulings they made, but with very, very little analysis. And unfortunately, because this is a novel issue of law, analysis is key. And the analysis in this case is, do the public policy considerations support treating Snapchat as a product? Judge, they absolutely do. And otherwise, Your Honor, Snap's position, if I'm being quite frank, is they're not subject to liability for anything in this case, which is why they writted your decision to allow the other claims to move forward in this case. They don't want any liability under any theory. And so there'd be no prejudice to them, Your Honor, to allow the strict product liability claim to proceed, to at least allow discovery on that issue. And if Your Honor doesn't want to make a final decision as a matter of law as to whether Snapchat is a product right now, it certainly can make that decision at the motion for summary judgment stage. Again, no prejudice to Snapchat in doing it that way. And frankly, Your Honor, I think that's more consistent with practice here in Nevada jurisprudence, and dealing with these issues. Another thing I wanted to address, Judge, he said that all of the cases we cited to involved Uber applications and Lyft, not necessarily true. We also cited the Grindr case. The Grindr is more like a social media platform. It's a dating app, essentially. And in that case, unfortunately, a child engaged in multiple sexual relationships with adults. And the child ultimately committed suicide, and the court in that case allowed that case to proceed. There's another case, again, this is all cited, Your Honor, so in our brief or our reply, there's a Maynard v. Snapchat case, Your Honor, where the court in Georgia determined that the speed filter element of Snapchat software was a product. That is directly on point. That is Snapchat and a Snapchat product. Okay. And they talked about there's 7 cases they cite that support their position. Your Honor, I count 9 cases that support our position. And so if we're going to look at the weight of authority, particularly recent authority, and authority that's consistent with Nevada law, many of the cases we cited rely on the second restatement of torts, not the third. Many of the cases that we cited use identical or similar language for the elements of their product liability law. And that's why we cited those cases. I can't say the same for all the cases they've cited, Your Honor. Many of the jurisdictions they cited have different standards for product liability, different public policy considerations, and public policy is incredibly important in our state, always have been. And so, Your Honor, I think at a bare minimum, if we're looking at the public policy considerations, the recent authority that's been cited, that supports the state's position, particularly at the motion to dismiss stage. With regard to unjust enrichment, Your Honor, I want to quote a statute to you, and it's NRS 228390, and this is a representation of public interest and customers' interests. And this states that it's subsection A, the consumer's advocate and this is at the Attorney General's office, has sole discretion to represent or refrain from representing the public interest and any class of customers in any proceeding. In exercising such discretion, the consumer's advocate shall consider the importance and extent of the public interest or the customer's interests involved and whether those interests would be adequately represented without his or her participation. Your Honor, the children's interest in this case would be inadequately represented without the state's involvement. Okay, and then moving on to NRS 2283.
How is this tied to unjust enrichment?
And I'm
I
gonna-
mean, I'm not questioning it. I don't think we questioned here today that the court's determination was based on whether or not your parents patriae or whether or not you're otherwise asserting that the state somehow conferred a benefit, that it's still, the court did not find that there was that benefit. So sort of honing in on, yes, the consumer advocate can represent citizens. I'm not connecting to how that enhances your argument on unjust enrichment.
And I'll get there, Your Honor. Just to kind of clarify, NRS 228390 subsection A does say that the consumer advocate has sole discretion to represent or refrain from representing the public interest and any class of customers, right? We're representing a class of young users, children under the age of 18 here. We're stepping in their shoes and representing them. So if the benefit was conferred by the users to Snapchat, we as the state are allowed to represent their interests and recovering for unjust enrichment. There's that. And then there's NRS 228308, public interest defined. So what's the public interest? And it says public interest means the interest or rights of the state of Nevada and the residents of this state, or a broad class of those residents which arise from the constitutions, court decisions, and statutes of this state and the United States, and from the common law. So, Your Honor, case law provides equitable relief. We're seeking equitable relief on behalf of a class of consumers here in the state of Nevada. And Your Honor, with that, I would submit.
Your Honor, may I just clarify one citation?
Sure.
That's all. I promise you, I'll just be
Okay.
2 seconds. So when I was referring to the thousands of cases, that's the in social media cases. Lengthy decision from Judge Kuhl. That's the consolidated cases. That's a 2023 Westlaw 6847378. That's what I was referring to as the thousands of consolidated cases.
Understood. I'm not going to take this matter under advisement at this time. I think when we're in a posture of reconsideration, it really does behoove the court to listen and ensure to the best of its ability that the way it called the balls and the strikes, so to speak, I use a baseball analogy, was to the best of its ability based on the law that's available to it. And I don't think that this is a situation that's driven by public policy. Certainly I can understand why the state is bringing the action that it's bringing. And the state certainly still has an action remaining, subject to, as you said, writ challenge by Snap. The issue here was far more narrowly tailored, and that was the court's determination in terms of how this platform operates, what this platform does, whether or not it can be determined to be a product for purposes of product liability analysis, such that design defect and failure to warn the counts 3 and 4 could stand as a matter of law. And ultimately, again, whether it could be determined that these users have, through the state, argued, but that the users, the citizens of the state of Nevada, children or otherwise, whether they are actually conferring a benefit for purposes of unjust enrichment. And I'm not going to focus on the recent public filing of Snap Inc. And speaking to its investors and or otherwise with regard to its as a stated product of Snapchat. At the end of the day, really, this is a products liability analysis under, to the best of our ability, Nevada relevant binding law, and to the extent that it has to look at and perhaps find some persuasive law to do so. And I am going to ultimately stand by the court's decision at this time and deny respectfully the motion for reconsideration. And my primary basis for that is the court can absolutely see a distinction between, and I'm not saying that this is all that was cited by plaintiff, that's not the point, but that the case law that appears to be evolving and finding the product liability, it appears to be something where there is in fact a product at the end of the communication, so to speak, whether it be a car ride, whether it be a date. I don't know what else how else to describe, as you cited, you mentioned Grindr. At the end of the day, what we have is a situation where we have a platform that's communication based. It is a communication platform. It may have functionality in ways that certainly has to set up systems, has some software, has other things. But what the challenge is, and what you continue to highlight through the public policy argument, is nobody wants people communicating where adults and children are communicating and then children are harmed, or adults and adults are communicating and then the adult is harmed. But these are communications. This is a service. The leap that's being asked to be made by this court to say that this is a product for strict liability product purposes, because in hindsight, we see a harm being made, and we should, by public policy reason, allow any avenue to sue to get to recompense for that harm. That's the tail wagging the dog. At the end of the day, I have to have something to hang my hat on, that this is a product for strict liability and or product liability purposes. And I don't see it at this point. I see that there have been some other cases in some other jurisdictions where those things have been found, but I'm looking at Nevada case law and binding precedent. And I think that right now still all stands for the proposition that this is not to be viewed as a product, but as a service. And while it may have some product components, not for product liability, is that available here at this time. And I will be very candid that part of my analysis too is if this court calls it a certain way, and depending on what other courts do, just like we've had prior in our court system where we had disputes among the district court judges as to how to interpret certain things. The quickest way and the soonest way to get our appellate courts to weigh in is to have divergent opinions. And I don't know what Judge Kishner's opinion is going to be. And regardless of what, if she had specific findings that were current and outcomes of ones that are still pending new dismissal motions, et cetera. If we have that, whatever those outcomes are, if they're divergent from this one, then so be it. I think you have a real solid basis to get upstairs and have our appellate courts review, and then they make the final decision. But based on the binding law that I have seen, and based on the persuasive law that I have seen, and when you look at this particular platform and its particular operations, I don't see the basis to indicate that this is a product for product liability purposes. And as difficult as that call is to make, because we're very cognizant of what has been represented as the public policy and the harms and the concerns, but we still have to fit this within. Again, I don't think this should be the tail wagging the dog, where because we see harm, now we have to figure out a way to sue that also implicates strict liability suit through products liability. It has to fit within products liability, and I just don't see it. Maybe the appellate courts will see it differently, and they will discern that there has been some evolution that now mandates this to be considered a product, and more details in the way it operates. But it's not finding a little piece here and there that could be considered a product. It's like, is this platform itself the product that is the strict liability? It appears to foster communications that falls short in this court's opinion, and it is not prepared at this time to reconsider and change that opinion. And it wants to have a definitive decision on the books, so that when the other judges come forward, whatever that decision is, you potentially have the opportunity to then take it up. As far as the unjust enrichment, that's not even a close call for the court. I am still not seeing any case law, any argument basis to indicate that these users, whether they're being represented through the state or the state itself, has conferred the benefit that is recognized for unjust enrichment purposes, to allow that claim to stand. So I do believe that as a matter of law, that there are no set of facts at this time that can be proven, and so that no discovery is warranted, that there are no set of facts that can be proven, that the court can see it as it sits here today, that would entitle the state to relief on the design defect, failure to warn, unjust enrichment claims. Now, again, I still leave this without prejudice, because as the case evolves, again, I can't at this point, as I sit here, see what that discovery would be, other than more instances where they called it a product, or more instances of other things. But there could end up being evolution in the case law that changes this court's analysis. There could be other information that's discovered in terms of the way in which the platform operates that could change the court's analysis, I suppose. But at the end of the day, I think that the focus needs to be on the other claims. The discovery needs to be focused on the other claims. And at the end of the day, should, through the relevant, appropriate discovery, something evolve that would allow you to potentially ask to amend in the future to bring one or more of these claims back, then the court will be open to hearing and reviewing that at the time. But I think the court is going to stand at this time denying the motion reconsideration on the arguments made by SNAP, and the court's analysis here today coming in, having reviewed all of the briefings and the arguments in the case law that was cited. I'll ask Mr. Blavin, Mr. Fagese to please prepare the order, obviously giving Mr. Sykes and company the opportunity for review. And let's get a final order here, and then we'll see what happens with the other cases, and we'll see what happens ultimately with any writ, which the court fully respects if anybody wants to do writ or other challenge to see if we can get further guidance from our appellate courts. I hear you, but I have to make the best call I can here in the best way I can, and that's my effort here today to do that. So thank you all for your time.
Thank you, Your Honor. And Your Honor, just to clarify, this is without prejudice if we do decide to file a motion to amend later down the road.
You bet.
Okay, thank you.